to the court case or the laptop.
Right. I'll just take a minute to thank everyone for taking out the time to come here on a wet Friday evening as semester draws to a close. This is the last masterclass that SOAS's International Law Program is organizing, and it is my honor and privilege to host everyone over here. And this is also particularly special for me since my father is here. He's an alumni of SOAS. He came to SOAS in 1984, and now I finished my LLM over here as the Felix Scholar. This discussion is about international Praxis. These are all practitioners. One is also a professor, he's also kindly volunteered to moderate this session with these practitioners. This is Professor Richard Tanzi. He's a prolific author, an excellent professor, and a very, very dear friend, and a very good mentor of mine. And I'm so grateful to him and to everyone else who's taken out the time to be here, not only on the panel but also in the audience. And those words, Professor, the floor is yours. I am also been advised to share that this event, that this event will be live streamed. We are not streaming, but we are recording. So, word of caution to our panelists. And with those words, I now invite Professor Tanzi to take the proceedings forward. Thank you.
Thank you very much, Ankit. Thank you very much for inviting me and giving me the opportunity to be amongst very important lawyers that I'm very happy as we go along to introduce and moderate. In fact, the selection of the panelists has been the result of a dense, intense, granular research in order to get the best of stimulating testimonials in the profession, in order to provide the broad picture. The only non-granular research was regarding one of the speakers that you may imagine who is sitting top left. You didn't have to make much of a research when you consulted me. What will you think? And I said, excellent choice. And I have, with very little effort, to justify the well-founded choice, and it will be proven easily in the course of the discussion. We are going to have 3 first-class practicing lawyers who became and are outstanding in the profession of applying international law in its different configurations, forms and shapes, perspectives, out of thorough study. All of them, one way or another, have been involved in legal writing. If we have to take excerpts from decisions handed down by Ali Malek in the form of an award, jurisdictional judgment, drafted by him, or suggested in his capacity as counsel, I suppose we could publish volumes. If we go through Monica Feriatinta's CV and list of publications, let alone the last book on sovereign immunity and immunity from execution, Oxford University Press, that's just one of many of the cubic meters of ink that toners of printers have been putting on paper. And the first time I met Anil Malhotra, I could recognize him by the name of the cover of one of his many books. Now, the perspectives that I'm very happy to see being presented by the speakers from their standpoint bring me back to the late professor, judge at the International Court of Justice, James Crawford, when he said in his seminal general course at the Hague Academy that most of what international law does, it does it at the level of domestic law. And I think that one of the red threads that may run through the discussion today will precisely bear on the relevance of international law at the domestic level before domestic courts, as much as the exercise of domestic jurisdiction to prescribe, to adjudicate, or to enforce bears one way or another on the degree of compliance or on non-compliance, which is of international law by domestic judges. In my experience, my first case in 1987, I had a number of experiences with cases that seemed to bear the name of girls. The first case was Elsie, that stands for Elettronica Sicula between the United States and Italy. And the dispute revolves around conduct by a mayor of a pretty famous, not for good reasons, municipality in Italy, Palermo. And when the disputed events unfolded on the domestic level, none of the actors involved would think for a second that international law was involved in any way, except that more than 20 years later the issue was debated and evidence being proven before an international court as a matter of fact and a matter of law. Another case, Enrica Lexi, another lady name, between Italy and India, bore on the exercise of criminal jurisdiction by the government of India, and many more to follow. So I will stop there, and I don't think it would render justice for me to introduce, with any attempt at precision, any of the speakers, if only because if you're interested, you probably know the whole story picture better than I do, even though it took me some time to go through CVs and biographical notes. The first speaker, Monica Ferriatinta, let me just say that her character as testimonial practice of international law stems from and evokes the multifarious, all-round relevance of international law, is very much linked to the all-round and multifarious aspects of her professional activity. In terms of the hats she has been, and she's read, counsel, arbitrator, presiding arbitrator, amicus curiae. You will probably may add also legal advisor to a government. So she has seen it and done it from many of the best of the world in international law. And Ali Malek. Let me. There's one thing that I noticed here, and another note that I want this to be missed. Monica, one of these specialized journals for lawyers, you see, like when you go to the coiffeur, you read certain specialized gossip papers, and if you are in a waiting room in a law firm, you pick through one of these gossip things, and Monica, described as amongst the most daring, innovative, and creative lawyers in the United Kingdom. Well, that is you. And another expression that captured my curiosity is this one, and I think they got it. A stylish advocate with incredible judgment, so much so that he decided that it was worth addressing you to meet us, which is a very good judgment. Thank you for that. And he is noted for his very attractive manner in court, which engages the attention of the judges. So no way that your attention span will fall during Anil Malek's presentation. Versed in banking law, apparently boring, but in fact extremely interesting, particularly when you represent and defend a central or quasi-central bank from a Central Asian country such as Kazakhstan, litigating with a US bank, just to give you an example, sitting as an investor state arbitrator or as the deputy judge in the commercial court in London, or also being, not only Monica is very brave, but also Anne is very brave. You understand, you have been practicing in Qatar, haven't you? And I understand the responsibility of arbitrators is being pushed to the extent that accountability there may end up in prison. I've seen some, so you're very brave because you risk imprisonment. That is what my research led me to. And so you see the various aspects of public, commercial, financial law being applied at my right-hand side. And on the left-hand side, last but not least, there is a lot which goes on in the international and transnational space populated by companies, individuals, and state officials that used to do with family law, particularly at the time when migration is increased and is constantly on increase, mixed marriages, separation and all that, and succession issues. We have a master who looks at this issue from a national standpoint, regional standpoint, and a global standpoint. And I thank you very much for enlightening us on all that. And now, without further ado, Monica, the floor is all yours. We structure it in 15 minutes each, the first round, and then we will be set. Thank you very much.
Thank you very much, Professor Dilettanzi, for that introduction. I first of all would like to say that my remarks are from the perspective of a generalist. I think that this is important to make this point because international law, in my opinion, and I think probably some of those who are here today, is a system, it's an international system. And there is an interconnection between different fields of international law. So I feel very grateful to my professors and to the Hague Academy that for me as an international lawyer, bringing that perspective, academically speaking, to my practice. And second, I think that I am not an international lawyer that was purely formed in Europe. I am an international practitioner that was originally formed also in a third world country. And I remark this particularly here in SOAS, knowing probably that there is students from all over the world. The importance of the word international in international law, which is really what makes the makeup of the multilateral aspect of international law in itself. So going to why is international law practice important? My practice as an international practitioner started at the point in time when issues of international criminal law were quite, I would say, visible. We had had a Security Council that had created the ICTY, something that had never happened before. The Security Council had never created a international court as such. And there we had this ad hoc tribunal that was going to prosecute crimes committed in the context of a war that happened in Bosnia, in Central Europe. So I went to work there and I started dealing with issues of command responsibility and also later at the International Court of Justice to work in the case concerning Bosnia versus Yugoslavia, the genocide case, which was the first modern case concerning genocide. And I am emphasizing this because this was a particular moment, internationally speaking, where there was a belief that domestic systems have failed somehow in addressing some serious crimes, atrocities, and the international system was reacting to that. So my first big job was, and this is how my career started, was to be a legal advisor at the Rome conference. So I stayed in Rome for about 5 weeks, together with all the delegations that negotiated the Rome Statute, what has become obviously the basis for the International Criminal Court. And this was the moment of, as the practice, I think that the moment was to accept, and Kofi Annan gave the opening remarks there, that we needed an international forum where the most serious crimes could be tried when domestic legal systems had been unable or unwilling to deal with them. And that put in perspective this notion of complementarity in the international justice arena, but also let's not forget that international law is in essence has a subsidiary role when it comes to justice. So to come back to the theme of domestic law, an experience that I had just around the same time was the Pinochet case. I had been teaching, being a assistant professor Christopher Greenwood, who was one of the main advocates pleading in the famous Pinochet case that actually changed the law of immunities here because the Supreme Court in England decided to interpret the statute in England concerning immunities, not to give immunity to a former head of the state that had committed torture. And I'm highlighting this because, again, it was a case of universal jurisdiction. It was a case that had not been tried in Chile, that couldn't be tried in Chile. It was a case where Spain had asserted universal jurisdiction, and it had been eventually been heard in England because the person physically was in England and Spain wanted him. So you can see how many jurisdictions are involved here, how complex is the context, but at the same time how crucial for remedies, which perhaps is a little bit the way how English qualified lawyers would look at this. In essence, the law is to resolve disputes, to provide a remedy. And I think that these cases marked really the very beginning of my career in international law, and taught me that international law could be extremely powerful. Now that hasn't left me since. I have had the opportunity to work on cases of pure international law. To give you some examples, and I will put it in abstract, an airplane downing. You have many individuals that have died as a consequence. What is the remedy? Often cases don't necessarily go to a court, although they can. Sometimes there are bilateral discussions and bilateral mechanisms, international claims as such, and ad hoc mechanisms that can be created. So the world of international law, it does not necessarily mean that it will be visible to all of us. The states have a lot of spaces where bilateral negotiations take place. Another example of how a case can be resolved, not necessarily going to court, is the recent cases concerning Iran and diplomatic protection. So I had the opportunity to be an advisor for the United Kingdom for about nearly a year, and I worked as in-house counsel. We had this big crisis of Iran actually detaining some dual nationals that had Iranian UK nationality. And I advised the government on some of these cases. One of the big cases that was in the media law was the case of Salam Ratcliffe. And as you may know, eventually her liberty was secured by precisely bilateral negotiations in a very, I would say, sensitive context. And eventually she managed to come back to England. So these are perhaps some examples where you can see how international law is relevant and important. There is obviously also interstate disputes, which is a very wide spectrum of cases. I've just started working on a case concerning law of the sea. Two states, one doesn't apply to diplomatic non-verbals, big issues, lots of people affected, and what do you do? So as an advisor, you look at what are the possible forums, and maybe interstate arbitration is one of them. Maybe there is PCA possibility, ETOS possibility. And what is important is that you can assist a sovereign, and through the sovereign, obviously populations that depend on the resolution of that specific dispute and addressing the harm caused. You can assist in getting a solution to that impasse. So that has started now. It's obviously under the Convention on the Law of the Sea. So we have an array of international treaties, all of them providing a possibility for understanding what the law is and what its applicability and what is the possible forum where you can go. Sometimes you cannot necessarily go to an international court, and this is where domestic systems may also play a role. And a lot of my practice also takes place in English courts. I have had the opportunity to advise on a wide number of cases. We had recently, for example, a very significant case concerning gold, the gold of Venezuela in the UK. Perhaps it's something that is going to be discussed a little bit in this panel, which is the interaction between public international law and commercial law. When I started my career, I thought that all these fantastic cases of delimitation, territorial delimitation, were just issues of pure international law. And later I realized that these cases came about because there were interests at the stake, most likely oil or gas or other natural resources, which put very much international law in context. There is always a context. And in the domestic context, we have had a number of banking cases. So I advised in the case of concerning Venezuela and an issue concerning Venezuela, the Central Bank of Venezuela wanting gold back from the United Kingdom. And there was issues of state recognition, government recognition, which was something that had not come across the courts for a while. And in many of these cases, you have to go back to, I don't know, when I advised on the diplomatic protection case, I had to go back to 100 years, which was the last time that the UK had actually granted diplomatic protection to anyone, and cover all of that. So this is how wide it can be and how complex it can be. So that perhaps gives you a little bit of a taste of the variety of cases that can pop up as involving international law elements. In the past, maybe 20, 25 years ago, it was less or so that international law would be that relevant in domestic systems. Today we have, that's certainly not the case. It is everywhere. It is important across, doesn't matter which state. I mean, just recently, we've seen a number of cases, prosecutions in Germany concerning Syria, and applying the principle of universal jurisdiction. In Belgium, there have been cases concerning statelessness. So those brides that went to becoming brides of ISIS fighters, etc., wanting to come back to Europe, and decision making taking place in domestic courts, extraterritorial cases, interventions across different wars around the world, and the application of extraterritorial laws, bringing the topic back to countries where originally there was no connection other than perhaps members, for example, of the mission being from the country in particular. So these are examples. Now, challenges. So we leave the challenges for the second round?
Let's.
Yeah.
But thank you so much for
So I leave it there.
Yeah, thank you for giving an overall picture of the various perspectives, which will all boil down to, even in the circumstance of what you defined as the purely interstate application of public international law, there is always a relevance and impact to individuals. take, for example, land delimitation between states, so many families will be depending either on their residence or on the financial exploitation that will come from the actual delimitation of areas that will be rich of natural resources. So the issue is being discussed and disputed by states, but at the end of the day, the impact is very concrete on domestic corporations, companies, workers, engineers, and the rest of them.
And can I just add to
Please.
that, peoples as well.
Peoples,
I mean,
groups
right now,
of
I mean, I think I have advised at least 2 cases concerning non-self-governing territories and peoples as a consequence.
Yeah.
And I think that is we still have them as subjects of international law.
The protection of indigenous population and their role is, their relevance is very much on the increase within the framework of purely human rights litigation, particularly, but not exclusively before the American Court of Human Rights, but investor-state disputes in Canada, in Latin America, in other countries. So, very much so. Thank you so much, Monica. Ali, the floor is all yours.
Thank you. I'm not quite sure why I'm here because I'm a latecomer, but I have to say I'm very pleased to see you. The reason I say I'm surprised I'm here is that I would not call myself an expert in public international law, certainly compared to my fellow panelists. The point I want to make is, and perhaps we can discuss, is where does international law come into a commercial practice? Because that's basically what I am. I'm a barrister who specialises in commercial law. I started off with doing banking, and perhaps I'll just say a few words about how the kind of work I do and where I think international law comes into it. I started practice a long time ago in a set with the fact of very little arbitration, and I would have thought no public international law at all. We were a very generalist set. In fact, we did crime, if my recollection is correct, is right at the beginning. But international law comes into commercial disputes. I remember going to see the great Ian Brownlee in All Souls, and it was a dispute, if my recollection is correct, about an account in BCCI held by I think it was the Iraqi embassy. And obviously I didn't know very much, so I drafted an opinion and went up to see Professor Brownlee in Oxford. And what impressed me is he had a safe in his room. That was the first time I'd actually seen somebody with a big safe. Now, the safe was not full of money, right? I assure you. It may have been, because I didn't open it, but the kind of work he did was so sensitive that his clients insisted that the papers be kept out. Because if you remember the traditional barristers' chambers years and years ago, you'd have all these papers in pink tape, and you could actually see what the cases were. I mean, you should have a great breach of confidentiality in that kind of setup. And he read my note, and he said it's not right, but it's the kind of argument that English judges will like. So then I left, and that was it. So it's a kind of gap between what a true public international law thinks and then what actually happens in practice, but an illustration of where an international law point arises in relation to an embassy bank account, which I suspect is a point that you discuss from time to time. I suppose the next sort of brush with the great people in public international law was with as was already mentioned, the great Professor Crawford, James Crawford. James, as you know, was from Australia, and he wanted to come to the English bar, so he needed to do a pupillage. So he asked me, could he do a pupillage with me? So I was his pupil master. So I had the great James Crawford. So you can imagine how clients felt coming in for a conference in my room and having Professor Crawford sitting over there. And he became a great friend. I mean, we actually did a lot of cases together. He would obviously focus on the public international law stuff in the context of of international arbitrations, which I'll come back to, and also bilateral treaty disputes. And so we did many cases together, and James, was a great person. I saw him about a year or so before he passed away in the Peace Palace in The Hague, and we've done many cases in the Peace Palace. It's a great place to argue cases. And what really stood out about him was his just complete mastery of the subject. And of course, when we talk about public international law, we're covering a vast area of different topics, whether it's the law of the sea, whether it's boundary, whether it's air, whether it's warfare, relationships between states, communities, all the like. I mean, it's a vast area, and I've never come across the vast majority of those areas, and it came up from time to time. So the question then arises: well, where does public international law come into what I do? And I suppose what I do is broken down into two different types of work. I do litigation, preparing in courts, and I also do arbitration. But I also, and I appear as an advocate, and I think you understand what an advocate is about, particularly a barrister. We are about arguing cases. It's about presenting arguments. We're not actually expressing an opinion as a barrister, but your personal opinion. As you recall, barristers always talk about, I contend, I submit. We never say, I believe the law on this subject is as follows. And it's a completely different function to the other thing that I do, which is to sit as a judge in national courts and sit as an arbitrator. So in terms of the national courts, I sit in the court. So in fact, I used to do criminal cases, which is quite amusing, considering I knew very little about criminal law, but great experience. I suppose one of my highlights was my career was giving a sentence in court number 1 in the Old Bailey. So it's a very famous court. So doing work now in the commercial court. I also sit in another court, and I'm not quite sure whether this fits in with international law, but the way that there's a whole series of courts that are developed. Arguably, it is part of international law. Which are the courts that one has seen essentially competing with amongst each other, but the new courts, whether it's in Kazakhstan, Abu Dhabi, Dubai, Singapore. The one I'm sitting on is in the Qatar International Court. I was there earlier this week doing an appeal with Lord Thomas, who was the former Chief Justice, and I'm going back on Monday to do another case. So that's sort of the court side. But there's also the arbitration side, in the sense that I'm an advocate, but I also appear as an arbitrator. I do work as an arbitrator, and that covers, whether it's ICC, LCIA, SEAC, and arbitration in Hong Kong, but also I do treaty work, and at the moment I've got two arbitrations where I'm the presider, the chair. So it's a mixture. I mean, one of the things that one can talk about in terms of, well, how do you balance between being an advocate and being an arbitrator? What sometimes called as the two hat principles. How do you manage conflicts? How do you manage the disclosure? And it is a difficult issue. You have to be fully alive. The short answer is that the way you do it is by disclosure. And making sure that everybody knows what you're doing. Just coming back to the question of how do they relate to each other. I've given an example of an embassy bank account in terms of litigations. There's also questions in terms of enforcement of arbitration awards under the New York Convention, and they obviously take place. And then there's and then you get into the international law issues such as immunity of states and attachment, and then I think it's already been covered by Attila. There's been issues about the nature of bank accounts held by central banks. What is the status of those? Can they be attached? And they give rise to fascinating issues. But these are disputes raising issues of international law. but in court. And as I said, I would not regard myself as a specialist, but with the help of people like Monica or Attila or James Crawford, as an advocate, you learn to understand what the arguments are and you can present them. And that, I think, is ultimately what advocacy is about. And if you try and think what proper advocacy is about, and what makes a great advocate, it's about simplifying matters. It's about making sure that the argument comes across in a way that is understood. And the problem is that if you are a super specialist and you know the subject backwards, you make assumptions, and therefore sometimes the point gets missed by the judge or the arbitrator. And that's why, as I said, it's breaking down the argument, going to the fundamentals, which really makes the great advocate, and is something that we strive to do. So that's sort of the court side of what I do, where international law comes into play. But it also comes into play in the context of arbitration. And, I distinguish two types of arbitration. I talk about straightforward commercial arbitration, between where a state may be involved, but then the kind of the bilateral treaty type dispute, which is separate, and I've done both. And sometimes again, public, international law issues arise. I remember doing a case many years ago in The Hague again, and ICC, and the dispute was about the supply of missiles. And there were a whole series of contracts. And the governing law was quite interesting, and I think I get this right. It was principles of natural justice. Now, that's quite an interesting governing law provision. And the first question that the tribunal had to decide, well, what does that actually mean? And if my recollection is correct, Vergara now on was the presider. And Crawford was in the case as well, which is how I came into it. He introduced me into the case. The majority, well, let's go to the dissent. The dissent was basically saying, well, this is all rather meaningless. This is just a straightforward commercial dispute, sale of goods. And the person involved was a very famous QC, as they were then known. I'll come back to QCs later, perhaps, if we get the time. But this is what that means. But he said, well, it's English law. So he said English law. And then the majority, however, said, well, what the parties actually intended here, they intended to be bound by, not by a national legal system, but by non-national rules of law. And so what the tribunal said, well, what's the source of these rights? And what they did is they came up with a hierarchy of legal regimes. So you start off with Unidroit, which at that stage hadn't been around too long. It was one of the earlier stages of Unidroit. And they said if the point wasn't covered, because this was a very complicated missile contract going over from, covering a whole load of aspects. If it wasn't covered by that, then it would be the UN Convention of Sale of Goods. And if it wasn't covered by that, well, general, international law. So basically, international law was part of the hierarchy. It was the last. Now, what actually happened? Well, what actually happened is that the main issue in the case turned out to be limitation, because what had happened was that this had happened a long time ago after a revolution. The parties had been negotiating with each other without prejudice, and so under domestic law, those negotiations would have been inadmissible and could not be referred to. So what happened working through the hierarchy? Well, was it governed by Unidroit? No, there was nothing on it. At that time, Unidroit's changed. Was it governed by the UN Convention of International Sale of Goods? No. So you went to international law. And what is the principles of international law related to limitation? It was leches, and that was how it was decided. And the great thing was that because under international law, leches, unreasonable delay, the fact that the parties were negotiating without prejudice could be referred to. So we got around limitation by actually running a leches defense, which is based on international law. So I do some international law, and but that's how it sort of arises. But sometimes the area where I suppose I do where international law is most relevant is in the context of disputes involving bilateral investment treaties. I did Romelli, I've done Sri Lanka, and Deutsche Bank, and that case is quite interesting because what it illustrates is the way, the interaction of the way that a dispute, a very similar, basically the same dispute can be tried in different ways. So what had happened is that they're a state-owned entity, Ceylon Petroleum Company, had entered into transactions, derivatives, in order to hedge against the price of oil which they were getting from Iran. And it was a complicated derivative. I think it was called a zero-cost collar, which essentially, if the price went down below a certain level, then the payment got bigger and bigger and bigger. And for Sri Lanka's point of view, it was a disaster. There were three banks, and the oil price slumped, and there was a claim, I think, between the three banks of something like $600 million, which for Sri Lanka was a massive sum, something like 15%, 20% of its GDP for a certain year. But the interesting thing, and why the case is interesting, is that there were three banks involved, and each had different dispute resolutions. And believe it or not, I did all of them. So on one there was an LCI arbitration, which was governed by English law, and we argued the case before a very distinguished tribunal, including Lord Middick and Johnny Gida and Michael Ryan, who were three of the top lawyers and great jurists, all three of them. And we won on a defense of capacity. And we said that this state-owned company, this I suppose is a link in the sense that quite often issues about capacity do involve issues of international law. But anyway, so we won on that point. And then I think it was about 190 million, so that was a success.
Can you elaborate on this?
Well, perhaps you can.
About capacity, how capacity helped you win the case?
Yeah, I mean, the capacity argument is that this was a state-owned entity, and therefore its powers to enter into contracts was basically governed by a statute, in terms of what it could do. And this was an issue that had arisen in London in many years ago in a case called Hammersmith and Swaps, where a whole load of derivatives, swaps were, liability was resisted on the basis that the various councils didn't have capacity to enter into the swaps, and therefore the contracts were ultra vires and void. So that was the argument that I ran. I said, well, look, this is a state-owned company. And therefore it has capacity to enter into risk management in order to cover risk, of the movement of the oil price. But what it didn't have is to have capacity to speculate. And I suppose I use as an advocate rather imaginative word, saying this was gambling, all that kind of stuff. But anyway, so that was the capacity argument, and it won. But then another bank, Standard Chartered Bank, had a different dispute mechanism, and that ended up in the commercial court in London. And the commercial court, they like upholding contracts and that, said, oh no, this distinction between speculation and risk management doesn't really work. And so I lost, went to the Court of Appeal and lost again, and then we were going to go to the House of Lords, as it then was, the Supreme Court, and it settled. But the one that I suppose was the most interesting and the most surprising was Deutsche Bank. And what Deutsche Bank did is they forgot about this. They didn't regard that to the contract. They said, oh, no, contract is something, but we've got a right under an investment treaty dispute between Germany, Deutsche Bank, and Sri Lanka, where CPC, so a claim was brought against the state. Now then, so the question then arises, well, what is the state responsibility? And this gives rise to a point that the jurists amongst you know about how contractual claims fall within treaty claims and the like, and whether they are inconsistent. But anyway, so the case went to a tribunal which was chaired by Professor Hannah, and so the international law arguments came in there, and my recollection is right. James Crawford was also was the person who was basically on the team at that point in time, and there were international law arguments. I mean, one of the issues was, well, how could the state be responsible? This was basically a contract between a bank and the Ceylon Petroleum, and they said, well, no. The central bank gave a direction that this derivative should not be paid. So therefore, there was an international argument about whether or not the state was responsible for the central bank. Then there was also a court decision which granted an injunction, which wasn't very long, but there was an injunction at one stage. And so the issue arose as to whether or not the state was responsible for the acts of the judiciary. And that gives rise to what I think the public international lawyers describe as denial of justice, and in what respect can a state be held responsible for the acts of the judiciary. In fact, there was a similar type of issue that I argued in the case called Rumeli and Kazakhstan, where it was alleged that a judge had been bribed in order to fix the result of the case. So again, the question of the responsibility for the judiciary. I mean, this is a topic that, if you're interested in, Jan Paulsen has written on a very good monograph on, which covers all those issues. But I think the point I'm trying to make is that the work that I do as a commercial lawyer, I would not call myself a public international lawyer at all. However, public international law comes in at various stages, whether it's in the context of immunity, enforcement of judgments, liability for acts of the state, and of course state contracts in some respects do give rise to international arguments. And another sort of derivative case which went terribly wrong was where in Portugal, where the underground, the metro, and the bus company, I think it is, they entered into these called snowball swaps, and I think they lost something like 1.8 billion euros in terms of things that went wrong, and that was fought out in London at first instance and in the Court of Appeal. So I think that's all I wanted to say. So just in terms of an overview about what I wanted, we can go into the detail of any of that.
I think it was splendid, and it made me reminiscent of a landmark piece of colloquial literature that I read from a speech which was published by Chaptal-Rosen, who was one of the greatest lawyers. Professor Chaptal-Rosen was on the court before the bench of the ICC, I think, as many times as Ian Brownlee and James Crawford. And when receiving the Hague Prize, for all these cases he did in The Hague, so the Hague municipality, which has this allure and reputation for being the capital of international law, gave Chaptal-Rosen this prize, and he said, let me give an advice to future lawyers, be them domestic attorneys or whatever. What's the use of international? How much international law should they know? Even domestic lawyers, if they want to be truly helpful to their clients, be them involved in a criminal law case, in a family law case, a commercial law case, you don't need to know international law, the law of the sea, investment law, or private international law to the fullest possible extent. but enough, which may not be little, but not too much, to be able to recognize that in any given case there is a public or private international law element which needs to be addressed in order to best serve the interest of your clients. And that is what I take from your words, and I thank you very much.
Shall I tell you the QC one? I was gonna
Yes, please.
Yeah,
Yes.
I'm a barrister. I'm actually now a KC rather than QC. In fact, King Charles came to see to Grays, and I was a treasurer a couple of years, so I met him, and he said to me, "What was it like being a KC?" And I didn't know really what to say, so I just giggled. But there is some misunderstanding about what we do. I think I remember I went to Chicago for and I got stopped by an immigration guy. He said, "What do you do?" And I said, "I'm a barrister." And he said, "Well, why are you here?" I said, "I'm going to a law conference." And then he said to me, "What is a barista doing going to a law conference?" So, and the QC bit is also not understood by everybody. I was doing a Formula One case in Paris, because that's where some of the disputes are. What had happened is that one of the driver's wheels had come off, which isn't very good when a wheel comes off, because it tends to bounce and it can actually hit people. So as a punishment, the car was going to be banned from racing in Spain. Now that was the car of Fernando Alonso, and not to be able to argue, to race in Spain was really bad. So I had to go in and sort of mitigate to say, well, it wasn't his fault that the wheel came off. These things happen, and it's terribly disproportionate to get punished for this kind of stuff. So I argued, and I was successful, because what happened is that his punishment was suspended, so he was able to race in Valencia, and everybody was very happy. But the funny thing about the case is that in the German press, I believe, I was reported as saying that Mr. Malik, head of quality control at Renault, argued. So not everybody understands what a barrister is, or for that matter a QC, but I suppose now that I'm a KC, I won't have that problem in the future.
Fantastic.
Anyway, a digression.
Lovely.
Completely irrelevant.
So,
No,
how do you feel being described as a KC and not a QC? It's quite a contrast, because conventionally you take silk, so you're a QC. So all of a sudden it's KC now.
I mean, it's funny, when I talk to people, they seem to like the Q rather than the K. But I mean, I think it's a nicer word.
It's a nicer
Like
word,
that.
and it's conventionally more privileged.
Is it okay?
Stands out.
I suggest we have an argument about this for the next hour. As to what people think. I mean, that would be really interesting.
There's a majority of women in this room.
Yeah.
Really?
Yeah.
So his KC is like saying all the king's men. But QC is Queen's Counsel.
It's also close to Kentucky Fried Chicken. So I'm kind of like lowering the standard a bit.
You can
KFC.
say, you can say it's KC is short form of KFC.
Yeah, exactly. If you want to be rude about some people, KFC after the name.
That's brilliant. Well, thank you very, very much also for this.
So I've lowered the tone of the debate. Now we'll become serious again.
Serious. Yes. So there you are, Anna, please.
So, friends, I'm on the South Pole. I talk of people and relationships of people. Conventionally, as we know, when international law touches individuals, private international law was born. Now, as I saw it as a student in 1984, 85, when I studied law and society in South Asia, it was with Dr. Veronensky, and international family law with Professor David Bradley at the LSE. It was two different interpretations. And I distinctly remember David Bradley saying, "Oh, the time is not far when the ceremony of marriage is gone and you go to the registrar's office, you're handed over a packet of condoms, and there you go. So are we going to return to a Victorian marriage? So I used to wonder, well, what is he saying is going to be true? I come from a country where we have no uniform civil code. We have 3.28 million square kilometers. We are a huge country, and we are 1.3 billion in number. To me, the state of Kerala or state of Gujarat is a foreign country because I don't know the language, I don't know the habits, and I don't know the culture. Because people are Tamil or people are Keralites or whatever. So, India is a sovereign, socialist, secular, democratic republic as per the Constitution. You have freedom of religion, you have right to free speech, and what we have in Part 3 of the Constitution, which we call fundamental rights. We have Part 4 of the Constitution, which are directive principles, which are non-justiciable. We are not a welfare state. We do not provide welfare as a true welfare state provides. And we have freedom of religion. Though we do not have a uniform civil code, every religious denomination, be it Hindus, be it Christians, be it Parsis, be it Muslims, they have their own codified enactments which the parliament makes. But then with the passage of time, these laws have come in clash when Indians migrate. And I have used the phrase international Indians in one of my 9 books. But in my last book, I have called Indians global Indians. Because we have a corpus of about 30 million Indians living in approximately 200 countries. And you will find an Indian wherever you go. Even when they say when Neil Armstrong landed on the moon, an Indian was already there. He says, when did you come? He says, right after partition in 1947. So that just goes to show the extent to which we want to migrate. And if you go back historically, the Kumagata Maru, the ship which came and tried to get into England, they devised all those ways. We still have a maximum number of Indians trying to get into England through the in small boats. But there comes a conflict. Our marriage is a sacrament. We do not dissolve it for the asking. We have a fault-based theory. You go to a country, you dissolve your sacramental marriage by a contractual process of breakdown. So you are married in India, but you are divorced in England. This was coined by the Supreme Court of India as limping marriages. But this concept grew slowly to abandoned brides, children left over, and the disputes got bigger. And they landed up ultimately into what has grown to a global phenomenon of inter-country, interparental child abduction. It is a law internally for most countries, but how does it take effect internationally? The Hague Conference of Private International Law has a convention called the Hague, the Principles of Civil Aspects of International Child Abduction 1980, which has been signed by over 100 countries. India has not. So wherever country to country a child is removed, signatory countries through a central authority return the child back to the country from where the child was removed. But India doesn't agree with it. But India has signed the United Nations Convention on the Rights of the Child, so it protects the best interests of the child. US is a signatory to the Hague Convention, but not a signatory to the Convention on the Rights of the Child. Now, unlike what Mr. Malik was saying, commerce, industry, trade disputes can take time to resolve. But when it concerns men, women, and children and families, they have to be sorted out. Otherwise, the effects are devastating. So, I would think that private international law is no longer a poor country cousin of international laws. And very soon, I think the Hague will discover an international family law I already call private international law international family law. Why? New concepts emerging in society have created such a need for a jurisprudence that you have to have principles regulating children and families, adoptions, abductions, surrogacy, division of matrimonial assets, marriages, divorces, nationality, citizenship. These are weird issues. I remember doing a case of a child born to a British national of Tibetan origin with a derelict. She became a derelict. She was a very high-end banker, but she fell into wrong hands and she procreated a child with a derelict drunk. So the local council took the child in care, but they didn't know what to do. So they got to me and they said, this lady, though British, is of Tibetan descent, and her sister in India is willing to take an adoption. Now you all must know that we have a huge Tibetan population, which came on persecution from China, but the Jawaharlal Nehru allowed these Tibetans, which whom the Dalai Lama keeps together. They are primarily based in Dharamshala in Himachal Pradesh, but they are also in a heavy number in Bangalore and Delhi. So this lady had 13 siblings. So one of them said, I'll take the child. But then how, by what process? This is where I come in. So they want to know how is the child going to go to India? By what process is the child going to be adopted? Would a special guardianship order of Britain apply in India? No. So I discovered that the child is Hindu guardian. So if you are Buddhist, if you are Sikh, if you are Jain, you are a Hindu. So I said the child is a Hindu, born to a Hindu mother. Her nationality doesn't change her religion. So her sister can take an adoption and the child can go across. But then the passport, the visa, but these are all very complex issues. While I was on my flight into England, I was frantically contacted by the Council of Bolton. I never knew where it was. And then I discovered it's somewhere near Manchester, near Lancashire. So there was this civil legal officer wanting to know that they have a child who is born to a couple from Kashmir. And the child is apparently under abuse, so the child has to be given in care to the Kashmiri grandparents in India. So they wanted to know what to do. And they said, we need to instruct you and we need you to find a solution in 72 hours. So I started going into the nitty-gritty and I said, is the child a Hindu or a Muslim? That would make a lot of difference. Then, another thing, Jammu and Kashmir was not considered to be a part of India, and all laws pertaining to India did not apply to the state of Jammu and Kashmir because of the special status. But in 2019 that changed. So Jammu and Kashmir are now independent union territories under the dominion of India. Now, was this child born before Jammu and Kashmir came into India or after India is going to be another issue. That will determine the nationality of the child. The child will take Indian nationality by virtue of the fact of being born to Indian parents. But the child would also be entitled to a British passport by virtue of being born in Britain. That doesn't happen if two Americans have a child in India, because India does not give any passport by birth to foreign nationals. You have to go back to the country. So this is all a very big riddle. So what is my job as a private international law practitioner? My job is to find a way on how to solve these problems to which conventional law has no answers. A couple married in Bangalore, living in Netherlands, the wife decides to walk out of the marriage and move back to India. The man persecutes the proceedings in a Dutch court and she's directed to come back. We try to cajole her into coming back. She resists, but ultimately she comes back. So the Dutch court proceeds to decide most of the things of alimony, of settlement of property and custody. But what happens to the litigation which the woman has initiated in India? How will it end? There is no international law which says this or that. You may stop them temporarily by anti-suit injunctions. Two parties litigating before two different courts on the same cause of action, the list being same, you can stop one, but it doesn't roll over. And the pandemic has created havoc in family law matters. Children left over with grandparents, children not allowed to go back, women or men come to courts. The judge says the child is already settled here. The roots have taken place. It's not in the best interest of the child to go back. So this resolution becomes very, very difficult. Now, every day, human relationships give me a problem more complex than the one I've handled before. I remember doing a case of a boy, a Sikh boy, abandoned in the streets of Southall by his parents, just left in the streets, because his parents were illegal immigrants, and they thought if they left him on the street, he would get British citizenship. No. The council took him in care, did a search on him, found his uncle in India, sent social services, checked on it, applied for a passport. The Indian High Commission said the boy has already got a passport, we can't give you any passport. So I filed a writ petition on the behalf of Borough of Ely in the state of Punjab and Haryana, seeking a mandamus to the government of India to issue him an Indian travel document. And I succeeded. But that was the extent of intervention the matter required. So all these problems, not related to banking, not relating to finance, not relating to revenue, are actually a very low priority for lawmakers, for states, and for policymakers. Because families and children don't fetch money. They don't fetch votes for the politician. So nobody is interested in changing laws. You'll be shocked. The Guardian and Wards Act we have in India is of 1890. It is an outmoded, antique piece of legislation which looks at singular custody. It is something which the British made for themselves when they procreated or they had children through local women, and Anglo-Indians came up. But what are we doing with this law? And despite so much of agitation and raising of voices, we are still where we are. So, change in family law is very, very difficult. Surrogacy has created a very big problem internationally. In India, it boomed from 95 till 2010. Multi-crore industry. Anybody could do anything. Then it stopped. Law came, foreigners would ban. It shifted to Nepal. There was an earthquake in Nepal. All pregnant women were at risk. The biggest were the Israelis. They sent in fighter planes to bring the women out, because a lot of the Israelis, gay persons, had done surrogacy. Then it shifted to Thailand. Then it shifted to Vietnam. And ultimately it landed in Ukraine. But the war brought horrors. There were babies born during the war lying in bunkers in hundreds, with 5, 10 nurses looking after them. Under Ukrainian law, till the parents did a genetic test to prove their connection, the child could not go. It is rumored that a lot of them landed up in Russia. And what will happen to them? One doesn't know. Now, surrogacy is in Georgia. In America, you can do whatever you like. England, you allow surrogacy, but in a very restricted way. It's compensated for expenses and so on and so forth. So, all these problems created by society today. Online marriages, I was telling my friend from Peru, I had a friend, a lawyer, he wanted to marry a girl in Peru, but they couldn't get to each other because travel was not possible. So I organized an online wedding. I don't know how they consummated the marriage, that we can't know that. But they read their vows online. They are happy in England now. But you have to find a way to do things. The biggest challenge for India has been inter-country adoptions. There were a lot of children under abuse, so the Supreme Court, through guidelines, led to evolving inter-country adoption law. But then India signed the Hague Convention on Adoptions. So country to country, children go through a regulated process. You apply in the country where you live, you are processed, you are given a child, all formalities are done, a court order is obtained, and the child goes back. India stamped out surrogacy. Why? Because they thought there was no mechanism to govern it. But I criticized it. I said you can regulate surrogacy like you regulated adoption. Screen people. In India, adoption is allowed to persons irrespective of marital status. But surrogacy is restricted to Indian men and women with proven infertility and 5 years of marriage. Ridiculous. The left hand of the government doesn't know what the right hand is doing. So policymakers in family law are grossly missing out on international law. You are not balancing human rights. We have carved out in the Protection of Women from Domestic Violence Act a phrase called relationships arising or relationships other than relationships of marriage. It's short of saying living, but we don't recognize living. But then there is a disparity of law. We don't recognize gay unions. We have decriminalized homosexuality. The criminal offense. It's ridiculous. Adultery was for us, I was telling them, most of the torts are in the Indian Penal Code. And that is something which the Britishers made in 1860. So how do we reconcile to international norms? We have to. So times are not far. Then there will be some global power, and Professor Malik will probably in one of his brain waves come out with something to do with public-private international law. I think the day is not far with this. And today you don't need to go anywhere. You can sit wherever you want and do whatever you like. Whoever needs you will reach you. Simple. But when it concerns real human beings, you have to resolve the matter. We had a Japanese case, a very famous case, of a couple who commissioned a surrogacy. But when the child was born, they were divorced. So the mother said, I don't want the child. Now, in India, a male father could not take an adoption or to have a child as a single parent because the child was a girl child. So he brought in his mother from Japan, and she filed a petition with the Supreme Court of India, and they granted her an exit. So this was a shortcome way. Now, I remember another case of a child called Baby Emperor. This was an Afro-Caribbean woman living in America whose husband had aerophobia, could travel. So she brought a sperm in a cryogenic jar to Hyderabad. She had no contribution, and she found a surrogacy clinic. Somebody lent an ovum, a surrogate gave birth, and the baby emperor was born. Now, when she went for a genetic test, obviously she had not contributed to the genes. But she was the commissioning mother, and under Indian law of surrogacy, the commissioning mother was the natural mother. In some countries, it is the mother who gives birth. So the passport officer said, I am so sorry, I can't give you a passport. I need to have your husband to do a DNA test. She says, you can't come. She says, then I can't give you the passport. She kept going there every day. And one day she said, all right, I'm leaving the baby on a table, it's yours. So the poor passport officer had to give her an emergency travel document to leave the country. So commercial disputes can wait. Economic issues can find resolutions, but human beings and answers to human relationships, you find the most complex of situations. You know, human beings can manufacture the weirdest of situations, and it baffles you on what to do. So, the need for an international family law, no longer called a private international. See, private international law, I think, is a historical term. It is now international family law. But how do you amalgamate family laws of different countries? The Hague is one of the answers. But if I don't like the Hague, what can you do to me? England is known to battle with these propositions, especially when there is a high-end litigation of the Saudi princes coming in with somebody, and there are children, and the Emir rushes to and hires a battery of lawyers, and then the issue has to be resolved. I think family law is coming abreast. At least in England, things are evolving. So, with this scenario, I look at what is growing into jurisprudentially such a vast concept, and it has to be resolved. See, a man or a woman, howsoever qualified, well placed, or exceptionally bright or brilliant he may be, when the problems of the child or the family starts bothering him, he becomes a maverick. I have known people, they lose their balance and they do weird things. I had a client who was the nephew of Lakshmi Mittal, the steel baron based in the UK. Filthy rich, married a pastry dermatologist. Child was born, she was on rave parties and he was looking at the child. He tried to claim custody, lost. He struggled but could. He hired a company of goons who took him to Nepal, and from Nepal he went to Dubai and became Muslim. So the High Court of Delhi caught hold of his entire family, and criminal cases were up against the whole family. So we appealed to the Supreme Court, and I was instructed to handle the family law matter, and we brought him back. Now the issue was that how do you resolve this? He has lost Indian nationality. He became a resident of the Dominican Republic, which nationality you can get by paying money, and he became Muslim. What happens to the child? What happens to the dispute? Fortunately, I argued before the Supreme Court that the family court had totally gone wrong after he had left, because the family court had transposed the mother in his place and given another custody without a hearing, without a substantial procedural law being followed. So, anyway, the matter got settled and resolved because the family law issue, the Supreme Court rightly sorted it out. Then there was another case of a gentleman called Karan Goyal, who succeeded in the family court after India said we will decide on merits. His wife appealed, he got visitation, he hired professionals and smuggled the child into the American embassy in Nepal. And the Americans gave him shelter because he was an American national and the child had an American passport. They gave the child a duplicate second passport, and he flew out with the child. Now, these are not ways of dealing things. There was a Dutch man who also hired mercenaries and took the child out of Mumbai. Now, these ad hoc measures don't speak good of international laws. We are not living in outer space that it's impossible to live along. But I think with Professor Tanzi and Professor Malik, some thought process will come, and maybe in the next few years we might have a structure somewhere.
And also, Monica, I think many of the issues you've been addressing touch upon human rights aspects, including international criminal law, including the recent investigations on and the decision by the National public prosecutor on putting is to do with children, and this is one of the area where Monica is a specialist, international criminal law, as she indicated from the outset. But can we have a second round and perhaps a quick question answer?
Yeah, questions we'll do Chatham House.
Answer
Questions
session.
Chatham House. So if you want to do the second round and then have questions, then
Yes,
Probably
let's.
Chatham House is-
I'm going to turn it off. I'll turn it off.
Oh,
For
right,
questions,
yes.
I'll turn it off.
But
Okay.
if we have to remain within the four corners of the big themes here, problems and solution and international law, don't be mistaken that as you rightly said, Ali, private international law is not international law unless it is a private international law issue which is being governed by an international convention. And the problem with international conventions that only states that want to join in the family of the parties to that convention are bound by that convention.
So only signatory countries.
It's and more than that, in those who have
And
ratified.
have made a domestic law incorporating the convention.
And what is the difference in the dimension of seriousness of the problems of private international law? Because commercial disputes between foreign corporations that are based in different jurisdictions is a private international law issue as much as a family issue is maybe a private international law issue which is governed by the domestic law of the judge who has been resorted to. Is that two foreign corporations may decide which is the applicable law and which is the competent jurisdiction, including doing away with any national jurisdiction and decide to set up an arbitration tribunal. When you enter into marriage contract, you can decide whatever you want, except that it is subject to the big limitation of the public order, which stems from domestic legislation, which cannot be done away with because there will be superior interest of the state. And at the time of the Enlightenment of the 1990s, where nationalism and legal nationalism seemed to be waning, and we had transboundary commercial issues being governed by some kind of a natural lex mercatoria, natural law of merchants. Unfortunately, that is a bit regressing, but not too much as family law is being still in the hands of nation states' jurisdiction to prescribe and to adjudicate and to enforce. So in an ideal world, when we talk about The Hague, we're talking about the Hague Conferences on Private International Law with a view to harmonizing national domestic legislations that bear on these issues, that if the states don't want to drink the water, you can make them drink. So without further comments, Monica, please, a quick reaction.
I don't know whether things are so clear cut like that. I mean, say like the Venezuela case I mentioned, you can think it's a banking case, a commercial case. It's a huge sum involved. And why is the impact of the certificate given by a particular state in the case? What was behind was the allegations of this particular state trying to recover the gold, that they needed that gold to buy the kind of necessary medical and sanitary, etc., objects to address the COVID crisis in Venezuela, which was really quite acute because of the lack of, they were living through a very huge economic crisis. So I think that what happens with law is that law is far richer. You cannot say sometimes that a topic is merely commercial or merely, say, if we talk about investment law, some of the cases that have been having a public impact or somehow coming in the news, etc., are those who, which were key for a particular state, whether it's a privatization of water, for example, or whether it was major environmental issues. So it appeared to be a commercial matter, but it had a very strong public law component and public international law component. And even in the case, for example, of minors that are taken for marriages, young women that are taken to certain countries to be forced to get married, the states got involved and actually ensured that they could come back, for example, to the UK, etc. So there you have a mixture of private and public, and I think that's a challenge, in a way, one of the challenges of international law and cross-border issues, that things are far more complex. You cannot see that just via one lens. You have to have the big picture. And I was formed at the Hague Academy, I mentioned before, and the examination actually was partially public international law and private international law, which was a way, in a way, to tell you from the beginning, this is going to be relevant for your practice if you are ever going to be an international law practitioner. Now, I think that fragmentation, and certainly here there may be someone that has been following that topic, is one of the major challenges. I mean, is the generalist a dying species, in international law, as international law has grown so much and specialization has just become a necessity? Is the generalist a dying species? I would say, that is a challenge, because you need actually the vision to see how different areas connect to be able to give a solution, and to have, as you say, to bring the big kind of leaps forwards in different type of cases. So I leave that as one of the examples of a challenge, and perhaps the second example of a challenge is unilateralism, that I think has been present in the last years, and vis-a-vis multilateralism. And finally, are international courts really equipped to do their job? And how far we have gone from what was happening maybe 20 years ago? I would suggest that procedural law has taken a very important role in international dispute mechanisms, and it's something that any international lawyer that wants to make an impact will have to master very well.
I love what you just said, because I've been spending my last few years focusing on my Hague course on Jura Novit Curia war topics, and I'm pleased to say that maybe it was worth something, because there is much need for further study on procedural law. Ali, your reaction to what has been said so far?
Well, I mean, when I listen to your cases, I mean, those cases are possibly more important than the commercial cases. I've always, my attitude has always been that the criminal bar is the essence of being a barrister, and those kind of issues that are really important. I mean, just as important as commercial disputes. Somebody uses some money, but where you're actually dealing with children and stuff like that, that's critical importance. I mean, the point I suppose that comes out of this is that, if you are not a specialist in public international law, what you need to do is to make sure that at least you can identify when a public international law issue is arisen. And that's why I go to people like you, or Cameron, or whatever that is, or 3VB, or Zach Douglas, or whatever it is. The moniker, I mean, it's that kind of ability to identify what the issue is. What I don't know is whether the public international lawyers think that the non-specialist judges understand and get it right. You think they do? Yeah.
They're not especially.
Yeah.
Well, I mean, Lord Sampson.
He could pick up
We
everything.
saw the Iraqi civilians case, which was a very interesting case of public international and private international law. 7 pages. It was brilliant, and I mean, I was just very impressed with how concise and sharp, and how the ability to actually see the connections between private international law and public international law in 7 pages was amazing.
And I think,
Yeah.
I think what one can say is that the powers, recognise the importance of public international law. And I think David Lloyd Jones is probably a good example of that. That's somebody who retired because he reached a mandatory retirement age of 70. The law changed to 75, and he came back. And you can see, the Venezuela cases and these public international law cases really require the brilliance that he brings to the case.
Lord Jones is a specialist, so he's a specialist in public international law.
Exactly. Yeah.
Absolutely.
Thank you.
Yeah, see, this gives me a thought. Why cannot the Hague Conference on private international law look at an arbitration mechanism in international family law? And under that umbrella treaty, have as many signatory countries as possible. Have an arbitrator whenever a dispute is involving two countries. He can decide on marriage, he can decide on divorce, which law of marriage, which law of divorce in which country. Arbitrate and resolve it. The biggest problem in these family disputes is pendency, length. If it goes on for 5 years, 10 years, it bleeds the parent out of money, resources, energy, and it creates very bad children. So what is needed is something expeditious, conclusive, and immediate. So if the Hague Conference was to look at a convention on international arbitration in family law disputes, I don't think anybody's even thought of it. We could have family law barristers then, money would start rolling.
From a lawyer's point of view, that sounds ideal. I tried my hand in international negotiation in environmental law to promote arbitration in torts, cases arising out of environmental harm. That protocol never entered into force, but it was already a step forward. The states accepted the idea of giving up their domestic court's jurisdiction on something which did not necessarily result from the will of the parties, the state giving up the jurisdiction of its own courts in such cases involving industrial accidents, but in a subsidiary way, residually from the jurisdiction of domestic courts. But at the time of nationalism, unilateralism, states, I believe, very unlikely accept not only arbitration, even the idea of setting up an international standing court in which the judges would be appointed by the nation states. That might be the way between domestic jurisdictions and arbitration. Could be an international standing family law, which I think would be a very, very much desirable step forward. But states are clinging to their jurisdiction. Imagine that one of the unimaginable but still, unfortunately, very much a problem is ethnic cleansing within the family of crimes against humanity. And that gives you an idea of, how you may have nationalism but behind it ethnicism, which sometimes identifies a nation state, religion and ethnicity. Would states, certain states, those who would be most interested in getting problems solved out of international relations pertaining to children, accept to give up their jurisdiction for an international status? Sovereignty.
Professor Gandhi, let's take it a little further. Human smuggling, human trafficking. It's a very serious problem. India is really sufferer. Canada, still trying to climb over the Mexican wall. But there have been cases where the man has fallen on one side and the woman has fallen back on the other side.
Let's be positive. We saw the problem, we see the hurdles, sovereignty hurdles. civil society has held the process of international processing, environmental law, human rights law. Let's get civil society into private international family law, pushing nation states to accept the idea of an international family
International
court.
family code.
Go ahead.
Exactly. Well, like the International Criminal Code, an international family code, and an international police, the Interpol.
Yeah,
Well,
the
you-
international
you-
criminal court was very much the outcome of the efforts by non-governmental organization kind. There's no peace without justice.
That's very true. I actually was an advisor because of the need to provide advice to states that didn't have otherwise legal advisors. Say like the United States had 60 advisors, but maybe a small little country had no.
That was Emma Bonino.
Emma Bonino, yes.
Emma Bonino.
Yes.
So let's create something of the sort with regard to family law.
But you know,
It's a great, it's a plan, it's a plan.
Okay, let's do it.
say serious consideration for the Hague Secretary General.
I have. You see, this was a very fruitful discussion and very.
But the sovereignty issue, I think what Alain Pelé says about sovereignty is very true. He says that obviously it is about how you have this monopoly of what happens, you know, and your own decision making within your jurisdiction, but there is also limits. So these are it has two sides of the coin. So what sovereignty also implies limits. Yeah. So I find that relevant.
Yeah.
We've been talking too much.
Yes.
Lady back.
Thank you so much for this fascinating sharing. I have a question.